Senator Alexander.
Dr. King, the Kerwin-Zeppos Task Force Report on Higher Education said that our 6,000 colleges and universities get on the average of one communication each workday from the U.S. Department of Education, whether it's a guidance or a memo or news about a new regulation. Is it correct that if that communication is simply a dear colleague letter, that it is not legally binding?
That's right. Institutions are responsible to the law and the regulations. The guidance is intended to share our interpretation of the law and regulations.
And if it is a guidance, it is not legally binding.
That's right. Now, the institution, of course, needs to be aware that we are sharing our interpretation of the law and regulations which are binding.
That you're what?
That we're sharing our interpretation of the law and regulations, that we're communicating through the guidance.
Well, now let's think about that a minute. So you're making the law?
No, we're providing our interpretation and how we interpret what their responsibility is under the law and regulation.
I had a visit with Mr. Donovan, the head of the Office of Management and Budget, and he was very clear that it was the Obama administration's policy that guidances and dear colleague letters are what you just said, not legally binding, and that when something is to be legally binding, it needs either to be a law or it needs to be a regulation that goes through the process of notice and all of that.
That's right.
Then who's going to tell Ms. Lhamon that, the head of the assistant secretary who's in charge of Title IX? Because when I ask her whether at a hearing, do you expect colleges to comply with your guidance? She says, yes, sir, we do.
So I think what she intended to convey is the point that I was making, that the guidance shares our interpretation of the law.
Yeah, but
and
if I'm at a small college out in Texas and I see that, I think she's making the law, and I don't dare not do what you want. And I think that goes back to Senator Langford's questions about the 2011 guidance about whether about these very difficult instances of alleged sexual assault, which are for every campus administrator probably the most difficult and terrible problem to deal with, and as well as for the alleged victim and in some cases the alleged perpetrator. And in 2011, the department put out a guidance and basically said equitable resolution cannot mean either clear and convincing evidence or preponderance of the evidence. It's got to mean preponderance of the evidence. So that would mean to me that the U.S. Department of Education could today initiate an action and say to a school, you're violating Title IX if you use the standard of clear and convincing evidence. Is that correct?
So let me first reassure you that in our communication with Senator Langford, Assistant Secretary Lhamon made very clear that we do not believe the guidance has the force of law. The guidance is intended to convey our interpretation of the law and regulations. We do believe that equitable resolution means preponderance of the evidence.
Well, who gave you the right to believe that? I mean, we were all elected, and that's not easy to do these days, or maybe even before these days. And that's an enormously important decision to make in the lives of students and universities. So the Congress specifically said equitable resolution and left that to university administrators and boards and others to resolve. Then you've come along and not in a regulation, but just in a guidance which isn't binding, you've changed the law for 6,000 colleges and universities. I mean, when you say preponderance of the evidence, that introduces a whole series of concerns about due process, which you also haven't addressed, and which, if addressed, we should be doing, not you.
Yeah. As I indicated to Senator Langford, the interpretation of equitable resolution means preponderance of the evidence.
Well, where in the world, where is that written? Where is that written?
That has been the long-standing policy of the department.
No, it has not. In 2011, a university could use either clear or convincing evidence or preponderance of the evidence. In 2011, you changed that by guidance, and now you, in effect, are making every university do that because they might fear an action from your department based upon that. legislating by the department.
We believe the guidance merely clarified what had been the longstanding interpretation when the department investigated a complaint on a Title IX issue. The department's approach, predating this administration, was to evaluate equitable resolution through the preponderance of the evidence.
But don't you believe that if Congress had wanted to make that important a decision about the level of the evidence required, that Congress would have written that out? You know, we can spell, we can write, we're very clear in what we seek to do. So I think I would strongly disagree with your interpretation of that. My time is up, Mr. Chairman.